So there you go. Here you go. Now we're running. Well, here's Harry Litticott's name again. It's Chief Deputy District Attorney. That's probably why he left the state. Superior Court of the State of California. This is a continuance. So it says here, Mark A. Muncy, petitioner, Department of Corrections, responded. The people of the state of California, the real party of interest. To the Honorable Court, the people respect request that in order to show cause, be extended to include March 2nd, 1990 for filing of respondents' documents. All right, let me tell you something about Delano County. March 2nd was a Friday. The only time they even have Superior Court or any kind of is on a Friday. And this is to include the end of Friday. And Judge Robert Ware says the order, the extension of the time response, file responsive pleading by the people and respondent is hereby granted to include March 2nd, 1990. It's signed right here, 2/21/90, Judge Robert Ware. Yeah, this ain't nothing. But I want to tell you a little story.
He's reading the Bible. He's reading the Bible.
This is Law Dictionary. Now I'll tell you the story about Humboldt County and Delano County law. This is after filing under the 5th and 14th Amendments of the U.S. Constitution on the right to due process. I guess I went through 4 of them. I didn't tell you that, but I'll tell you now. But this is where it's at. And we're already up to a year or so later. After I already served my sentence, if you want to read my transcripts and everything else, and California's looking for me, and they know where I'm at, and I don't care. But this is how Delano County runs the court system. The first thing under K, you see that? K says kangaroo court, a court that has no real legal authority and that disregards all the rights normally afforded to a person. Its conclusions are not legally binding. This is a slang term for Humboldt County. No, Delano County. No, I'm only kidding. But it's a slang term referring to a court that is biased against the party and thus renders an unfair verdict and judgment. Right there, right at the law library. Now, I want to tell you the rest of the story. After I filed this petition and the response from the Department of Corrections and Attorney General's office.
No.
There was no response made. I contacted the DA's office. I went through everything I could to find out what happened. Nothing happened. So, Chief Deputy District Attorney Harry Litticott Jr., who's now presiding, I guess, in Washington, he had to take the matter in his own hands. You know, here we go. This is under the 5th and 14th Amendments. And this is a matter of Superior Court of the State of California for the County of Delano County. Mark Muncy, petitioner. Versus Department of Corrections. People of the State of California, the real party in response. This is after 2 months.
That was to clear your throat, man.
Huh?
This road's clogged
All right, sorry. This is my response. This is not from the respondent. This is from Harry Litticott of the Delano County. And you might ask me why I'm here and this and that, but listen to this. Okay, I dealt under the 5th and 14th Amendments of the U.S. Constitution the rights to due process, which they've been totally denied. And I feel sorry for everybody out there, but like I'm coming back, so don't worry. This is not from the Attorney General's office. After, if you look at the habeas corpus where they exposed it, all the respondent never responded. He's like a rubber butt. This is this is Delano County. All right, this is what it says. After considerable research, the people have concluded that there is a split authority concerning the claims made by petitioner. Check all my writs out and anything else you want. Henry Cabrera, which I follow, it says, Henry Cabrera, 5th District, 1983, is agreement with the petitioner's posture. That's state. Henry Chablis, 1st District, Division 1, 1981, is contrary to petitioner's contention. There's no listen to nothing. Then we go to Allen versus Bonnell, 1989 Journal, 14691 cites Carter versus McCarthy, 9th Circuit, Supreme Court, 1986, 806 F2D, that's the Federal Reporter, page 1373. As controlling law in that district, Carter stands for the position that failure to advise the defendant of a parole condition makes the imposition of such conditions improper. The people therefore submit this matter. Dated March 22nd, 1990. I got handed this piece of paper on March 23rd, 1990, while I was standing in front of the judge and trying to understand this and what the judge said. But here we go for, Delano County. Here we are, Delano County again. Mark Muncy versus Department of Corrections, 90-003.C-3. Based upon Henry Chablis, petition for writ habeas corpus is denied by this court. Law in motion, original. Now, I want to tell you a little story about what Ellen and Bonnell says. I know, I didn't have it, that was my right for my transverse and everything else. I have nothing else left. But this is Ellen versus Bonnell. Cites 891 F2D, 9th Circuit, 1989. And this is what the Supreme Court had to say. This matter is controlled by Carter versus McCarthy, 806 F2D, 1373, 9th Circuit, 1986, which held for the purpose of determining whether a plea of voluntary and intelligent, the purpose of determining whether a plea is voluntary and intelligently made, the critical fact is not that the imposition of parole term is mandatory, but that the parole term is to be served in addition, that's an important word, now I'll get back to later, to the term of confinement under the sentence. In these circumstances, the judge handling the criminal proceedings must advise the defendant, which is me, inter alia, of the maximum period of liberty may be restrained both by way of imprisonment and parole. See, I filed into all this, and it's really ridiculous, because that was 7, 8, 9 times, and that is that. But like here it keeps on going on. It says, thus, under California law, informed of the California mandatory parole provisions, a defendant could be required to serve an actual sentence imposed plus, that's how they put the plus over there on the side, plus a mandatory parole imposed. This court holds that if a defendant is not informed of a mandatory parole requirement, then the maximum time in custody plus the status cannot be exceeded the length of the actual sentence imposed.